I'm gonna see. Hi, welcome to our newest installment of the our NPS Empower Hour presentations. So tonight, excited that we've got a little bit of a different topic than some of our usual topics. A lot of times it's about the future of what it'll mean when you have your union, how that works. But we're going to talk with a different side of our union. Oftentimes we talk with our representation side. We're going to be talking with our Office of General Counsel, as well as our field operations. So really excited that we're going to be talking about legal updates on what's going on in the courts, what has been happening in these cases that are affecting federal employees in so many different ways. And each day it sounds like there's like a new case and like, did this union get this or did we get this? And then what happened with this next step? So we are joined with a couple of folks who are going to help us break that down tonight. So happy to introduce our Director of Field Operations, Dan Casper, and Associate of General Counsel, Will Lee. And I think with that, I'm going to hand it over to you all to tell us what's going on and I think a little bit about our Office of General Counsel.
Will, do you want to get us kicked off?
Yeah, absolutely. So first of all, thank you all for joining this call. I'm really happy to be able to talk to you all. I'm an associate general counsel in NTU's Office of General Counsel, which is a small office of about 9 or 10 attorneys. And I'd like to say that we definitely punch above our weight. So what I'm going to do is I'm going to tell you a little bit about what we do in the Office of General Counsel and that how that kind of fits within the entirety of NTU. So Dan is our director of field operations, and his field reps do the really the day-to-day of the work with our chapters. And I used to be a field rep, but when I first started at NTU, I was a field rep, and I still kind of miss some of that day-to-day stuff. But in the Office of General Counsel, we, unlike a lot of our other brother and sister unions, we handle a lot of our work in-house. So any litigation that we file from our national headquarters comes through our Office of General Counsel. All of our matters that really impact multiple chapters will come through our Office of General Counsel. Um, so in sometimes, in what you might call peace times, we are doing more litigation like Fair Labor Standards Act cases, things like that. We're still doing some of those. And in fact, we've just resolved a couple, these cases that are getting folks, their proper overtime hours, things like that, getting them various pay differentials, things that are really kind of what I usually consider the bread and butter of kind of like the representing employees. That being said, we don't live in ordinary times. And in these times, we also handle a lot of our affirmative litigation to defend union rights, and to defend the union. The biggest things that we are litigating in front of courts right now, include things like fighting back against the administration's reductions in force. There have been several of those at various agencies. Um, uh, so the CFPB. There have been a couple of rounds of RIFs, including most recently during the government shutdown. We filed cases there. We have also filed a case. It's hard to it's kind of crazy to think of that it's been over a year, but it's been a year and a month since the executive order came down that tried to take bargaining rights away from employees at many of the agencies that we represent. Now, ostensibly, this was done supposedly on some mostly national security grounds, but if you looked at some of the justification, including the justification that the administration used themselves, this was pure retaliation, right? They didn't want people fighting it back against this administration's agenda. So it was very much kind of this core issue of who's going to stand up to this administration. They didn't want us doing it, so they said, "Well, you guys don't get to have union rights anymore." And so we soon after that executive order issued, we filed a case where we've been litigating it since, including right now it's up in front of the D.C. Circuit Court of Appeals, where it's fully briefed, fully argued, and we are awaiting a decision. And my colleague Paras Shah, who is our general counsel, has been doing an incredible job, kind of spearheading all the different pieces of this litigation, as well as all the other pieces of our litigation. That's something that really sets NTU apart from other unions. A lot of unions will kind of farm out their litigation work on this kind of stuff. We do so much of it in-house. We'll still partner with some of our sibling unions, of course, and we have done so to some pretty good effect. But it's really one of the really cool things about NTU is that we really do a lot of our work ourselves. And I think that makes us stronger because we keep it in-house. Um, I can pick up the phone and call Dan and say, "Hey, what's going on?" And it makes it much easier, makes us much more responsive, much more flexible. And so it's a great place to be. We've really done a lot of wonderful work, even if the topics are sometimes a little fraught, right? And so one of the other things, and I'll turn it over to Dan in a second, but one of the other things that we do, in addition to file these cases, is recently, and all the time, you'll see these agencies trying to pass rules, trying to issue regulations. There is usually a notice and comment process, and so we will comment on those and say, "Hey, this rule that you're proposing, it doesn't make any sense, or it's going to hurt federal employees. You guys need to consider this." And one of the important things about that is that when we file them, um, before they issue the final rule, or when they issue a final rule, the agency has to address the comments. And if they don't, or if they don't do so adequately, then it gives us more of a rationale to then take it to the courts, right? To say that the rule wasn't passed properly or was arbitrary. And so you see, we kind of are participants in this process from beginning to end. And a lot of that also involves, hearing from members um, who might be affected by a certain rule, who might be affected by certain executive orders issued by this administration. And so it's been a great place to work, and I look forward to doing some more of it with Dan and the rest of the team.
Thanks, Will. We were trying to figure out how we get probably 10 hours worth of material, the litigation, everything that's going on right now, and squeeze it into the 30 minutes we had today. But we're going to try to hit some of the high points for you, as Will just did an excellent job of. So my name's Dan Casper. I'm the Director of Field Operations and Organizing at NTEU. I've got the pleasure of overseeing our 8 field offices across the country. All those field offices have assistant counsels and are led by a national counsel, and their main role is to be a liaison between our national headquarters or national president and all of the chapters that we have the pleasure of servicing and supporting. And, of course, I also get to oversee, and I don't have to introduce them anymore. You already know Lee and Stephanie very well, and all the incredible work that they've done organizing externally, internally, and everything in between as well. What I really wanted to talk to you about, I'll certainly get to the legal aspects there as well, but, the role that we in the field get to play with the Office of General Counsel has changed so much because of both the amount of litigation that's come in and the type of litigation it is. I like Will's phrasing of peacetime, which is, I mean, we generally aren't in court all too often during normal times. Why is that? The reason is because the labor statute that allows federal employees to be able to organize, select your representative through an election, and have us represent you. That labor statute is designed to have most disputes go directly through labor arbitration, grievances, the Federal Labor Relations Authority, the Merit Systems Protections Board, the Equal Employment Opportunity Commission, all of these what are called administrative channels and administrative fora. When Congress passed this statute back in 1978, the compromise and all the discussions around this was we're going to have these expertise agencies, administrative agencies, and labor arbitrators that can help solve disputes so that labor relations are as good as they can ever possibly be. There's an easy way to solve these disputes, and that serves labor peace and it serves the American people. Frankly, so we aren't in peacetime right now, to state the obvious. And that has made NTU look in a different way at how we strategically fight back against things. Trust me, there's still lots of arbitrations going on. There's still lots of things at the MSPB, the FLRA, these other administrative fora, and I'll talk to you a little bit about some of the MSPB reduction in force separations that Will had talked about. But the action right now, writ large, is in the courts. Will talked about the exclusions executive order, which is attempting to exclude 2/3 of NTU's members that we've been fighting now for over a year and a half. It doesn't impact the National Park Service right now, but it impacts Bureau of Labor Management, which NTU proudly represents a number of BLM members and had filed a petition, at a time in several places for BLM, which is on pause right now as we're continuing to litigate against the exclusions executive order to be able to represent those members as well. So the way that it has changed for us a little bit with the Office of General Counsel now doing so much litigation in court so often on these things, they work with us hand in glove in field operations. They often need information like that, overnight, sometimes next day information in order to get that prepared to support the great work that they do in the courts from a lawsuit perspective. And who do we in the field rely on for that? You all, the folks who we represent, our members, our chapter leaders, and so on and so forth. You all, when you're able to join into you'll see all the great things that we do, but you'll also understand that the role that you play in helping us to be able to be successful in some of these lawsuits is humongous, because we are not on the ground able to gather the information, represent accurately, what's going on an ongoing basis every single day. So that's one of the ways that we've really, worked with Office of General Counsel. I want to talk to you a little bit more about some of the work that we're doing at the Merit Systems Protections Board on the reductions in force, just because I know that is a hot topic across the government, and use reductions in force as a quick survey of all of the different places where NTU is to try to bring about representation. Then I want to ask Will, a few questions too, and just go back and forth a bit. And then hopefully we've got some time for some questions from you all if you have them. So reductions in force. When the Trump administration came in about mid-February or so, they started mass terminations of probationary employees at many different places. Very shortly thereafter, there was an executive order that added reductions in force to that as well. The gist of the executive order said, we want to shed a bunch of federal employees, and we're going to do so via terminations of probationary employees and reductions in force. NTU filed a lawsuit that is still ongoing right now that said the combination of terminating probationary employees, mass reductions in force, and the DRP program, the Deferred Resignation Program, are acting together in concert to try to break the government, to try to dismantle the important missions that so many different agencies are doing right now. So that is the court action that is attacking reductions in force right now. We also have uh, a we have grievances, but we've got a Merit Systems Protections Board for those. So the Merit Systems Protections Board is where we can take NTU what are called adverse actions, anywhere from a 15-day suspension up to including removal. Can also include separations via reductions in force. Because of a lot of the work that NTU and other unions did to push back against probationary employees and to push back against reductions in force, many of those things actually were stopped, at least so far, or were significantly pushed back or scaled down what the scope of those things were going to be. One place, though, that they really hit hard was Health and Human Services. And we represent, probably 18 to 19,000 employees at Health and Human Services. And we had about 1,200 NTU, employees, bargaining unit employees who we represented, who were separated via reduction in force on July 14th of 2025. And we amassed through multiple departments, our negotiations department, field, and office of general counsel, 35 attorneys over a 30-day span filed appeals for 650 HHS members. And we're moving forward with those, right now going through the Merit Systems Protections Board. So that's been a massive undertaking, but it's been well worth it. And because of it's being recorded. So because of the idiocy, I'm going to say it, of the agency and the way that they did some of these things in terms of just trying to blast right through this stuff, we're really hoping for some success there. So the third prong, though, is grievances, too. So normally you can't grieve both separations of reductions in force. You can't grieve probationary employee terminations, generally speaking. But what we've done, we worked in concert with the Office of General Counsel to come up with a strategy where we grieved what are called the institutional rights, and to use right to be able to bargain the impact and implementation to try to mitigate the effects of a reduction in force. Now, we do that all the time. We've been doing it for decades. Here, they blew right past that. But our strategy is going to be that if we win on the institutional right, which is NTU's right to bargain, the remedy for that is a status quo ante remedy that would return things back to the way they were before. And guess what? That would bring employees who had been separated via reductions in force under our theory back to before that reduction in force happened as well. So it's just an insight. There's a lot of other, areas that we work on where you can sort of attack it from multiple ways. But that's just kind of the life of a reduction in force and the way that we're trying to challenge that. Will, I wanted to ask you, we've, we fought back against a number of, the OPM rules that have come out, recently. In fact, speaking of reductions in force, a couple of those have been designed to strike back at unions' abilities and others' abilities to challenge reduction in force separations.
That's right.
Probationary employees as well. They've tried to further limit the already somewhat limited rights of probationary employees there too. And then the other thing that's going on right now is actually dealing with representation at the FLRA. The FLRA has proposed a rule to try to pretty nakedly, try to make it so that the politicals are the ones who can make a final decision. Thankfully, that's not going to impact our National Park Service employees that are on the call right now. My question for you is, all right, people ask, OPM FLRA issues this proposed rule. NTU puts in comments, for it. We have our members actually put in comments where we supply bullet points for them to use too. But then what happens? The agency issues the rule anyway. What does the Office of General Counsel do once that rule is final?
Yeah, that's a great question. And it, you know, one of the when I was saying earlier that we kind of get this ball rolling from the ground floor. This is what I'm talking about, right? So, for take for example, on the proposed rule to change the structure of the FLS of the FLRA, right? The Federal Labor Relations Authority, for years, has had the same structure where basically they have a two-tier decision system. Decisions go through their regional offices first before they get to, like you said, the politicals. So we're working on comments right now to basically point out how um, and they tried to make it so that they tried to suggest that that was just a procedural thing. Obviously, it's not a procedural thing. It's substantive, right? And so one of the things that we are going to try to make clear in our comments is that these are substantive changes. Um, and kind of like you said, we also encourage our members to submit comments. One of the things that agencies always look for when they are looking at comments is, how interested are people um, in in this rule, right? You know, it's not just it's not just who's commenting, but how many people are commenting. And so by marshaling our resources at the beginning, thinking about how best to make those comments, what to say, and then tell our members, hey, go ahead and submit comments. It's really it, it's really a concerted effort to both say why as well as with a lot of strength of all of our voices, not just the centralized unions, right? But so what we'll do after that is after we get those comments in, we'll look at the final rule that the agency puts out and sometimes one of the interesting things is you can always see who is they'll say these days they refer to like a specific comment number, but you can look back, you can refer back to the comment that was made and say, hey, this was our comment, right? They either said they considered our comment or they tried to dismiss it somehow, but when we see that, that's kind of the interplay that we need to say when we are considering filing a lawsuit to say, hey, this does not meet the standard. You did not meet the standard that is required. And as a result, your final rule, which didn't properly consider our comment, or just kind of gave it short shrift, it's arbitrary, it's capricious, and those are the legal standards, right? So we're thinking about the legal standards that we have to meet in order to get one of these rules overturned. Um, and so that's how it kind of proceeds all the way from the beginning, because only by only by making those comments and saying, hey, you need to consider this. In order to be reasoned, you have to consider this. Here's why you shouldn't do this. The agency has to think about all those things. And if they don't address it in their comment, that really gives us kind of the ammunition we need to go out and file a lawsuit. And so it's starting from, all the way from the beginning, from when the agency puts out that proposed rule. We get in on the ground floor, Dan and Paris and I and other people will talk about it and say, hey, what is the impact on our members? And we'll take it all the way through, including hearing, encouraging our members to comment. And then we look at what the final rule is. And really those arguments that we need to make in a lawsuit, we'll have thought about that, right at the very beginning. So that's kind of the strategy that goes into the comment kind of procedure.
And I do have one other question for you, Will, but
Hmm.
before I do that, Lee, Stephanie, I want to see if there's, because I'm actually not able to view the comments or anything. So I want to see if there's any questions so that we make sure we get to those if there's anything in the chat.
Nothing in the chat so far.
Awesome, thank you. So
Okay.
Will, the question I wanted to ask you then, just to highlight this piece, because I think it's one thing that we didn't talk about yet with the interplay between field operations and Office of General Counsel. So,
Hmm.
and it's because in the past it hasn't had to happen all that often. However, I talked earlier about arbitrations and the MSPB and all these administrative fora. And quite often, when we have those fights out there before an arbitrator or before an administrative judge, that's the end of it, win, lose, or draw.
Right.
Because
Right.
under ordinary times, the standard for appealing something is quite difficult, sometimes, especially if you're trying to challenge the factual determinations. But here, um, we're expecting all sorts of things to be appealed, and many, many more issues get up higher to the courts, to include potentially the Supreme Court as well. So, field operations has been doing a lot of arbitrating and a lot of litigating, on our side, as you know, with the deluge that's coming your all's way soon. So,
Yeah, that's right.
uh, I just wanted to highlight the piece and see if you have any comment on it. But when there is an appeal of some of these initial things that the field operations, that the assistant counsels, the field reps handle those
Hmm.
things. Oftentimes, the Office of General Counsel can either take an appeal, follow that case up to the courts, or try to enforce something if an agency is not moving forward where we want a decision at the lower level. So, if you want to
That's
just
right.
talk a little bit about that, please. So,
Yeah, sure. Um, this is particularly the case now when you have these agencies that are basically repudiating, bargaining agreements, right? You have probably some situations where you have an arbitration, which is something that's mandated under the statute and under collective bargaining agreements. Um, the field has been winning, I feel like, winning these arbitrations left and right, which is great. But then the next step is to make the agency actually, follow through with what the arbitrator, orders as a remedy, or in some cases, show up to arbitration itself, right? But a lot of that is happening at the field level. And if uh, if if it if the agency does have kind of the intransigence to just say, hey, no, we're not going to follow these orders, by these binding orders from an arbitrator, that is when Office of General Counsel can get involved. Depending on what type of arbitration it is, it may go in, different kind of directions, right? Um, uh, Historically, we could potentially, go to the FLRA, um, to seek enforcement there. With some of these, there may be, litigation that comes out of it. And that again kind of gets to the importance uh, of kind of this communication between departments, right? And we've definitely had situations where we kind of advise, or work with our field reps to kind of say, hey, if what do we need to do to kind of preserve the issues for appeal? What are the time frames? We are certainly in some kind of unprecedented time, so we need to make sure, we don't miss any deadlines like that may be applicable, right? So, these are all things that we have to think about. And, one of the benefits, again, of NTU is that we work very closely together so that we can think about all of these issues, and make sure that all of our I's are dotted and T's are crossed so that we're all ready.
that's right. Well, yeah, we as I said, Will and I could talk about this, for hours on cases, and we'd love to come back, to and speak, more if there's any specific, cases you want to talk about. But we wanted to give you a flavor on some of the things that we're doing now, some of the most important and some of the most recent, stuff for sure. All this litigation is taking, it's sort of, turn in the limelight right now. This is not normally where we are, with unions. I mean, we always have litigation and formal representation going on, but the NTU hope and the NTU model is always for this litigation to accompany general chapter building and development work, and engagement with members on all sorts of things. Every piece of litigation formal that we do We do not only for for those specific members, but these are things that we want to share and within the agencies, within chapters, across agencies, too, so that everyone understands all the good work that our chapters are doing for everybody, and how when members stand up for themselves through collective action, that it's just a beautiful damn thing. So we're super, super honored that you had us on here. We are excited about the upcoming elections that'll take place, and we look forward to welcoming you to the NTU family as well. So, Lee, Stephanie, anything for us to wrap up?
There are a couple of questions in the chat.
Sure.
So one is thanking you for being here tonight. Has the administration been successful in limiting or canceling any collective bargaining agreements while the cases are being litigated?
No, it's been successful in sending an email saying it is canceling a contract, but not aside from that. And I say that only half in jest, but OPM has directed agencies to send unions messages saying that they are withdrawing from arbitrations and canceling the contract. But they're the only they're the only ones who are following that, right now. So, I'm in Seattle. I flew from from DC over to Seattle because we have a national training conference with many chapter leaders here that we get together for every single spring. It's several of these, and we teach areas of the law, and we get together and we juice each other up to get ready to go fight more. And on that flight over, 4 arbitrator orders came in denying agency attempts from 3 different agencies, just on my flight over here. So we are doing what are called ex parte cases, where if an agency doesn't show up, arbitrator says contract is still in place, litigation's ongoing, so this case goes forward. And they will give us victories if, we still have to prove our case, but we don't have an agency going up against us. And those are the cases that Will said that even if the agency doesn't recognize that arbitrator's order, Will and the Office of General Counsel are working to enforce those in courts.
Yeah, and the only other point that I would make there, right, is that even OPM saying to agencies, "Hey, go ahead and repudiate these contracts," even that took a long time, right? Because at the very beginning of these litigations, this administration was at least a little more careful in trying to say, "Oh no, we haven't implemented anything yet. There's no effect of this. We're just kind of like." Setting up setting up the dominoes or whatever, right? We're not actually tipping anything over. And so it took them a long time for OPM to come out and say, go ahead and repudiate those contracts. That's in part because we fought them so hard
Right.
and dragged this out for so long that they finally gave up and said, go ahead and repudiate them. But even that, like you said, Dan, is just a letter. They haven't actually gone to the FLRA, which is where they need to go in order to get these collective bargaining agreements essentially declared void because there's no bargaining representative anymore. So they haven't done that yet. They're probably trying to set that up, but that's not. But thanks in large part due to all of the steps that we've taken, they haven't been successful yet.
That's right.
Two more questions in the chat. What is the status of any actions or litigations around employee performance evals? We know that almost all NPS employees were improperly rated last year and expecting the same or similar this next year.
Yeah, there's a couple of points on that. There is obviously a wide scale effort across the government right now to bring down the performance ratings in many different ways. Some of them are doomed to fail for sure. Some of them are, will be at least a little bit more difficult and present more of a challenge, to push back on. The ones that I think are probably doomed to fail is there's this thing called a forced distribution that some of you all may be familiar with, which is just decades old, that you can't have, a forced distribution, meaning X number of people get fours, X number of people get threes, X number of people get twos, no matter what. So that they're trying to do that. I don't think that's going to be successful. But they're also saying, everybody needs to basically be harsher in the way that nitpicky, however you want to say it, in the way that they're evaluating people. And the regulations that are out there right now talk about how when you're evaluating performance, you're evaluating on a person, on an individual basis. It may be that you have a department where everybody is unsuccessfully performing. It may be you have a department where everybody exceeds fully successful and everybody is a five. You have to look at it on an individual basis. They're trying to say the ratings are too high and therefore managers are doing poorly, too. Whether managers are doing poorly in some aspects for some people, who knows? That is a much more difficult problem than just trying to wipe it across with a brush. Last thing I'll say, and then see if Will has anything to add, is, we have pretty extensive contract protections for performance appraisals, there. But like so much that's going on right now, agencies, managers, under pain of being terminated, by people above them, are not always paying as much attention to that contractual language. So, as General Counsel Parshah likes to say, it takes only seconds to break something and takes longer to put it back together. So we've got a lot of performance appraisal grievances, both attacking a policy from a national level grievance and for individual employees as well, that we're challenging, against these things. So, Will?
No, I agree with everything you said there, right, Dan, because it does have to be individualized. It can't be, the forced distribution is like you said, the kind not, the most outlandish of the proposals, right? Like they just can't do that, right? But we are seeing them try to propose rules that will kind of like chip away at the protections that have been that federal employees have enjoyed for so long. That's in large part because they don't like those protections, right? But we're also well situated to fight that both at the policy level, pushing back against those rules and comments, that rules through comments and possible litigation, but also on the on the individual level. Uh, for individuals who unfairly get dinged for various reasons, whether it's by a manager who feels pressured to give everybody lower scores, or somebody who just doesn't uh, give somebody the consideration that they are entitled to under the federal rules.
Here's a question about the new FLRA rule. How will the proposed changes in the FLRA impact the process for parks that have not yet petitioned for a vote? So we have two petitions that are already, making their way through and election scheduled for at least one of those regions. But then we have a number of parks who are on standby to file for add-ons once we get those units certified. And it's likely that they would fall under the new rule, possibly.
Yeah, to be determined. I think we can reasonably say that the rule that the FLRA puts out is going to have most, like the final rule is going to have most of what the proposed rule had. They did this rule in a way that was not the correct way. Will talked about the correct way, which is you have a proposed rule And if you get a bunch of comments in, it may take you a while to look through those and genuinely consider them, meaning it could take quite a while to pass the rule. Well, the FLRA didn't want to wait for that, here. And so it said, to Will's point, it said, this is just kind of a ministerial, thing that we're doing. We're pushing some paper in different places. And so we only need 30 days, for this. So FLRA will issue that rule. And one of the biggest issues with that rule is it was not clear what the actual process is going to look like within the FLRA. There are three members of the FLRA. Two of them voted to propose that rule. The other one dissented. A big part of her dissent was you don't even explain in your proposed rule how the hell this is supposed to work, in the first instance.
Right.
So I don't know how it's going to impact, people, both from that procedural perspective. Is that going to cause things to slow down because, you now have this bottleneck instead of multiple regions looking at it? You've got the three members of the FLRA who, by the way, have a day job where they're supposed to be issuing decisions in other cases, too. And then the second thing is, does the FLRA scrutinize areas of representation law in a way that has not been done in the prior decades? But we say to be determined, because I just don't know yet. So, Will, any other thoughts on that?
I mean, it really is. It does illustrate how kind of haphazard and chaotic that they're looking at this, because you're right. This kind of like alleged ministerial change, it doesn't have any. There's not really any indication of how they plan to run the ship, basically,
Right.
possibly because they don't intend it to run, right? But the effect of that may well be to slow some things down. It could create bottlenecks. It could lead to more kind of political decisions. That being said, um, I think ultimately, the votes are the votes, right? And so they'll happen one way or another. We might just need to be prepared to push back against some, pardon my language, but procedural BS, right?
Yeah.
So,
Yeah.
yeah.
Yeah, and there's different ways that we're certainly looking at about whether the rule itself may be unlawful, and we may be challenging the final rule, as well, and not just us. As Will said, we talk with our sibling unions on these things. And frankly, it goes beyond unions as well too. We talk with
Hmm.
Democracy Forward,
Yeah.
ACLU, a lot of other outside entities on these kinds of things.
And I believe it was just a few days ago that the NTEU president, Dorian Greenwald, put out a statement to our chapter presidents about NTEU fighting this particular
Right.
rule from FLRA. So there is, we're just kind of waiting to see how we need to fight it, is what I'm
That's
hearing.
right.
So the National Park Service did implement a forced distribution this last year. Can you tell us a little bit about other agencies, or what other agencies did the same type of thing?
Yes. So it's interesting. We've heard from others that they did a forced distribution as well. What we've found is one of two things. Either the people from the other agencies told us that they did a forced distribution, but that's kind of what their management chain had told them, and their management chain had confused the fact that OPM had put out a rule about allowing forced distributions, and management thought that was already in there. So that's happened, and sometimes where it's just the confusing nature of it. Through the telephone game, some people thought there was a forced distribution. But others have done it without it being the policy. Where, I think you can tell that some higher level managers in some agencies have gotten together and say, this is going to happen anyway. Let's start moving toward that in that direction. So, forced distribution through oral meeting is just as unlawful as one is, through having a written policy. It's just a little harder sometimes, to prove because you'd have to get all the, you got to do a lot of discovery and get a lot of information together as well. So um, there's just, like I said, there's decades of case law that say that this is not okay. There's a regulation that says it's not okay, which is why OPM is trying to change that regulation. The argument that we make, among others, is the regulation simply implements what the law requires anyway under the statute. So they can't change this regulation, regardless of it. But it's difficult to challenge it yet until the actual final rule comes out, unless you challenge it through individual grievances that you're filing. It's tough for us to, at sort of the policy level, um, go from the top and challenge something because no agency has put out their guidance yet saying, here you go, we're doing it now. We have a forced distribution. They're not doing that yet because they don't want to get out in front of OPM, which is changing the regulation.
I think we're going to transition to Q&A so that people can, just unmute themselves and ask questions. But right before we do that, I'm going to just turn the floor over to one of the organizers from the Pacific West region to just talk a little bit about what's going on with our petition for election, and just talk about what the feeling is from the Pacific West region side. Go ahead, Nico.
Hey, yeah, so I think most folks know me. I'm Nico. I'm from Joshua Tree, but and this is my cat Bagels. Um, but I was thinking today about where we're at, and just now realizing that uh it's been about almost exactly 12 months since this effort started forming up in some of our minds, and we started having our first 1187 signed in May. Um, we started reaching out to NTU, almost exactly a year ago. Um, and it has been a crazy year of organizing and getting to know each other and coming together in a way that national parks, at least in the Pacific West, never have. And and in the Intermountain region and getting that effort started. And it's been such a wild ride. And now we're actually within sight of that first goal, which is actually, getting to our election, getting our union rights for real. And being able to access all these things. We've been having at least 6 months of Empower Hours, and learning about the benefits of a union, and we're going to start to see those benefits real soon, which is just very exciting. And a lot of this stuff is pretty, at times it's exciting, at times it's community, and at times it's just super boring. It's we're looking at lists, Excel sheets, and we're talking about legal stuff, and we're talking about what the OPM policy says about this and such, or what the FLRA does, and throwing out acronyms and putting people to sleep. But that's all that substance there is that thing we've been fighting for. That substance is a bunch of people who still want need the Park Service to exist. Every one of us, I've been saying all year, every one of us that's here right now had the opportunity to leave, whether it was through just not signing up, not fighting for another seasonal job, or whether it was through that deferred resignation. We all had the chance to pack our bags and get out of here and go do something else and take that free vacation, that illegal free vacation, but to take that free vacation. And we stayed because we really want, we care about this thing, about this work that we do, about, the dream that many of us had of being park rangers as kids. And that fire that's within us that lets us, makes us want to do this no matter what, is also the thing that NPS has taken advantage of over so many years. The drive to be in this agency is so great that people don't want to, take risks to make it better.
Yeah.
And what we've seen this last year is that like that's no longer guaranteed that this agency will still exist and that these parks will still exist and that these jobs will still exist if we just take it on the nose like we have been for so long. And so that's been what we've needed to come together and to stand up and fight for workers across the Park Service. And it's something that I hope that we never lose going forward into our careers. And, many of us will become supervisors and many of us will become leaders in the Park Service. And we're not going to give up on this agency and we're not going to give up on these parks no matter what. And we know that because we've been through this year. And so I'm really excited to carry this energy forward into an election. I'm really excited to have people like Dan and Will standing up for us, going to court for us, going to bat for us. And I'm really excited to have all these parks come together and, and form our unions and become stronger together.
Yeah, it really is a great an amazingly impressive organizing community that both regions have built independently of each other, but then also jointly with these two regions and also the Midwest region and Alaska as well. So, this idea of unity and supporting each other has really grown in leaps and bounds since we, started having these talks last year about this same time. So I am going to let it open up to any questions. If you have a question for anyone on this call, Dan or Will or myself or Lee or even Nick, you can unmute yourself and ask those questions now. Or you can put them in the chat if you'd rather. Give it a couple more seconds for questions. Any closing thoughts, Will and Dan?
Kind of to echo what was just said, the fact that you all are doing this right now, I admire that a lot. You are coming together and organizing and building and learning some of the boring stuff, that you have to, you put that all together. But what you're building is something that is lasting and good. And I really admire how everybody does that, particularly in this moment. So thank you.
Yeah, drive that home, further. That's exactly what I was thinking about too, Will. It's hard to come together to do the work that it takes to build a campaign to organize together, to become a part of a union under normal circumstances. Right now, oftentimes you got that extra piece, perhaps for some of the conversations you've had with your colleagues who may say, what's the point? Or let me wait till a better time or something like that. But now is when it's necessary more than it has ever been before. And it's incredibly impressive that you all have stuck through this and grown and gotten to the point where very soon here you're going to be able to advocate with your colleagues to vote and to join Lee, Stephanie, Will, and I in the very, very large and growing NTEU family that we have. So we really, really do appreciate you letting us spend some time with you. Will and I love to be able to do these kinds of things and talk with you all. And we wish you the best of luck throughout the election period. We'll be rooting for you, and we can't wait for you to be NTEU members. So have a good night.
Thank you. With that, I think we'll go ahead and start to wrap up. Our next Empower Hour is going to be May 11th. Let me double check. Yes, May 11th. And it's going to be a kickoff in our Get Out the Vote campaign for election. And so you'll definitely want to tune into that to find out all the election details and processes and procedures that we'll be going through in order to get everyone a ballot and make sure that everyone has the opportunity to vote in those elections. Other than that, we have our regular committee meetings going on. So Pacific West Region, tomorrow night, we'll be talking a lot about elections and informational sessions regarding the election coming up. So thank you to Dan and to Will. This was incredible information, and we appreciate you in so many ways. And everybody, have a great evening, and we'll see you next time on May 11th. Bye, everyone.